and that's the United States Patent and Trademark Office. Filing a lot of trademarks on behalf of my clients, and actually some of those clients aren't even necessarily entertainment clients. They're businesses that want to make sure that their names and their brands and their logos are protected. I also deal a lot with the United States Copyright Office, and I looked it up. That's actually not an administrative agency. We're a branch of the Department of Commerce. That's what the United States Patent and Trademark Office is. So, and it makes sense, though. There's a difference between the two. When I'm registering a copyright for clients, copyrights, anyone yet? One person? Did Professor Rorty?
No, we had an adjunct, Matt Nellis, talk.
Oh, okay. I know
Scheduled
who
for
he
the
is.
fall.
Yes. He's one of my favorites. And he does a great job with that class. So, well, does anyone know what a trademark is and what purpose it serves at all?
Yes. Well, the trademark is like one of the best ways for, articulate branding, like a company who has invested a lot in their, products, and they've built up a significant reputation based on like either their products and the logo that's associated with that product, and they want to protect that at all costs.
Exactly. And that's why the Department of Commerce regulates the United States Patent and Trademark Office, particularly trademarks, because it has to do with your brand value and the name that's associated with your products. It's a source indicator. So what I do with the United States Patent and Trademark Office is I file applications with them on behalf of my clients. And it gives my clients the ability to have federal protection under the Lanham Act and some sort of course of action in the event that their trademark is infringed upon. There's actually something called common law trademark, and you can have that even if you don't have a federal registration, but with the federal registration it gives you added benefits, statutory damages, attorney's fees. So when actually filing an application with the United States Patent and Trademark Office, there is a review process. They actually have attorneys within the United States Patent and Trademark Office, and I'm actually just going to say USPTO from here on out, because the other is a mouthful. There's USPTO examining attorneys that are actually assigned to a particular application, and they review the application to make sure that the word mark is of a level that is actually protectable, because there's certain words that are generic and merely descriptive that actually don't rise to the level of being able to be trademarked federally, unless they get a secondary meaning. So they review the application, make sure the word mark is of is either suggestive or arbitrary, unique, and then they look at the actual description of the class of goods or services that you're applying under. There's several different classes. I commonly register in class 41. That's for live performances. I also register in class 9 for sound recordings for my music clients. Also class 25 for my clients who have merchandise like fashion, clothing lines. I have a client with a really cool hat line. And then there's others as well. I represent a lot of social network kind of websites like Facebook, and those I consider entertainment too, for obvious reasons, and they fall under a lot of other different classes as well. So you file the initial application, and then the examining attorney reviews it, and they write you back. And usually they say everything's okay, or they say there is a likelihood of consumer confusion with some other marks that are registered, or they don't like how you've described it, and so they want it to be clarified. You can't really broaden it. And they base everything that they tell you on it's called the Trademark Manual of Examining Procedure, and that's something that's written by all the attorneys that work in the United States Patent and Trademark Office. It's this, basically it dictates what applications can be registered, what you have to have in them, and it also talks about when they can be rejected. It tells you how long you can have a trademark for, when you have to file for a renewal, etc. And then there's also some rules that talk about the judicial proceedings that occur within the United States Patent and Trademark Office. And I think that goes, you're probably talking a little bit more about that process and how the administrative agencies sort of have their own kind of judicial process, similar to the process in courts, where they actually make decisions instead of having to go to court. So with the United States Patent and Trademark Office, usually when you think of causes of action involving trademarks or patents, you think of infringement, when somebody's using your name and it's causing consumer confusion as to the source of the goods or services. So like if I wanted to start my own beverage company and name it Pepsi, for obvious reasons, I would get sued for trademark infringement. Well, you only have recourse in the courts for that kind of cause of action. The judicial body within the United States Patent and Trademark Office is more of a, you can't actually file for trademark infringement within the Trademark Trial and Appeal Board. What that allows you to do is if somebody's using your mark or they file a registration for your mark, you have an opportunity to be able to oppose that application and file an opposition, which is similar to filing a complaint in federal court, but not really for a trademark infringement cause of action. It's rather you're saying, hey, these people don't have rights to the mark, they weren't using it, I started using it before they did, I have rights to it, and you can actually do that either as a registered trademark owner or somebody who hasn't even registered your trademark. And so it's this process where you file like an opposition, kind of like a pleading, and then they have the opportunity to answer that pleading.